Can it be on Thursday? We are having little difficulties, my lord, though the matter is intensely important, my lord. Item number 22 on Thursday, my lord.
Okay. On request made by Mr.
Thursday, my lord. SP Bhattacharya.
S.P. Bhattacharya and Bhattacharya and got this time. Sir, you want it on Thursday?
Thursday, lordship.
Okay. 9th.
My lord, I'm deeply obliged, your lordship.
Mate. That is item number 31 for today's case, my lord. I may be allowed to withdraw this petition. He has got the all pensioner benefit.
Mr. N. Barua.
N. Bora.
N. Bora, then counsel for the petition. Submits that the matter has become infectious. Who appears for the other side? Mr. Ardar, and the addition senior government advocate. Appears for the respondent number 1. Stop. The petition is accordingly disposed for present purchase.
May please. I beg to mention for withdrawal, my lord, tomorrow.
May please, your lordship. Also, I'm praying for listing a matter on 10th for orders. Friday, my lord, for orders.
15th.
15th. Oblige, my lord.
May please, your lordship. Lordship, with concern of the other side, I beg to mention item number 20 of the daily list, my lord. Here you have received copy of the affidavit in opposition, my lord. Where you intend to file a short reply, my lord. May I pay the matter will be taken after 2 weeks.
How much time you require?
2 weeks, my lord.
You, Mr.
R.B. Guhai on behalf of Mr. M. Biswas.
On request made on behalf of Mr. M. Biswas, then the counsel for the petition. 2 weeks time is allowed to file reply to the counter filed by the respond number.
Allah responded.
Filed by the respond. List of 2 weeks.
May please, your lordship. I am praying for listing of a repetition on 15th, lordship. On 5th. Obliged, lordship.
May I please, your lordship? Lordship, I beg to mention the SMC matter. It may be listed on 9/11/23. New matter,
What
SMC.
matter?
SMC matter.
When do you want?
9/11/2023.
Is it a fresh matter?
Yes,
Motion.
yes, lordship.
We'll have it on 15th.
Obliged.
Item 1 of daily list, motion.
May I please, your lordship? Lordship, kindly peruse the order of this honorable court dated 27/10/2023, lordship.
Yes.
Well, after that, they have, lordship, passed an order, lordship, whereby the petitioner has been attached to the office, lordship, of the joint director of CASA. In fact, lordship, we have challenged a particular order whereby the lordship private respondent numbers has been transferred.
Where is the order? Infusion order?
My lord, that is page 50. My lord, partially they have given the benefit by the letter.
He was allowed to work on attachment, lordship.
Yes. Then what happened?
My lord, partially, lordship, some benefit has been given. That is, the petitioner has been allowed to work under attachment in the state office, lordship. Perhaps, lordship, this order is required to be challenged. My lord, may I pray, lordship, this notice may be issued in this case, and petitioner, lordship, in the meantime, lordship, will challenge this order, lordship, also. Because this is the order under attachment, lordship. We want, lordship.
You want the attachment order to be challenged?
My lord, that is to be challenged. So
then why should I issue notice in this?
My lord, this is the order. This order is required to be interfered with. That is page 50.
It become infractions, lordship.
No, cannot
Yes.
be.
Last occasion also for The director has passed the order, Lordship.
My lord, without considering the prayer of the petitioner, the prayer of the respondent number 5 was considered. Without any basis, lordship, this order has been passed.
No, this order has been modified.
No, this order has not been modified. This is the fresh order, lordship. That is order dated 4 November 2023.
Mm.
This is the fresh order, although it is passed, lordship, in terms of the order of this honorable court.
Mm.
But
What
this
is
is,
this one minute?
lordship, by the impine order, lordship, private respondent number 5 has been transferred. But by the order dated 4 November 2000.
1 minute. Yes.
So this is the order, lordship, whereby the private respondent number 5 has been transferred by the impine order. And by the fresh, that is the order dated 4 November 2023. The petitioner has been allowed to work under attachment. My prayer is that this impine order is to be set aside and petitioner should be posted on transfer, lordship, not on attachment. So we are not, lordship, seeking any interim order against this order. Your lordship may simply issue notice in this case, and in the meantime, lordship, the petitioner will challenge this order, and both the matter, your lordship, may be taken up with that.
But Mr.
M.
M.
Khan.
Khan, General Counsel for Petitioner. Issue notice. MS
D. Bora,
D. Bora, then the Standing Counsel,
Health Department.
Health Department. Appears for respondents. 1, 2, 3, and 4.
Yes, Lordship.
Petitioner to take step for service of notice on respond number 5 by registered to the state within 1 week from today. List after respondents are allowed to file on the list of the 4 weeks.
My lord, notice,
I'm issuing notice.
No.
4 weeks.
oblige.
To admission.
Lordship, my senior is having some personal difficulties today, Lordship. So kindly the matter may be taken up any other day, Lordship. Pleadings are complete.
Who's your senior?
Mr. UK Nair, Lordship.
Okay. Okay. On request made on behalf of Mr. Yukinara, then it's your counsel for the petitioner. List after 2 weeks. 2 weeks.
Much obliged.
3 to 18 and supplementary 32, 33.
May it please the lordship. Well, this series of matters were fixed by our lordship on the last occasion, the reservation in promotion. My lord, before I proceed, I'd like to say that there are 2 categories of cases which your lordship will now specify.
I'm seeking some accommodation, sir, lordship.
My lord, he has already sought for, taken my consent. My lord, that I'll come after I make my submission, because I'm not objecting on there here. My lord, what has happened? After the single judges had passed an order whereby the reserve were denied the benefit of merit through a clause, that offending clause was set aside by the single judge in the Bhagavan Patar's case, and they went on appeal, the other party. The judgment on appeal also in the second round, they lost the case because the court held, division bench held, that promotions will be cadre-wise, and the consequential seniority which they were arguing that it has been withdrawn is not, that has been rejected by the division bench. So two categories of cases are now before Lordship. Item number 3 to item number 8. In these cases, we only want implementation of the division bench's order. Malad, I'll satisfy your Lordship. As regards what had happened, in the meantime, the government goes for an OM, which basically overrules the judgment of the Bhagwan Patar. That we have challenged, constitutional validity was challenged. It had gone before the division bench. The Chief Justice said that let the single judge decide the matter. But we had an advantage because two forums, our contentions were accepted, and the High Court order, division bench's order and the single judge's order were in consonance with the Supreme Court's order. What I want today, since Mr. Chaudhary has some personal difficulty there, he has sought for some time. I was reluctant because of the urgency. Item number 9, where the constitutional validity of 2003 is under challenge, that may be fixed on next. We have fixed the date also. We have agreed to a date. Let it be on Thursday next. No issues. So item number 9 to 18 may be fixed on 13 because they have an issue. But as regards Lordship, 3 to item number 8, Malan, those have to be segregated because I will satisfy a Lordship. It is only for implementation. Why?
So you want a segregation of this?
Yes. Item number 3 to 8 may be fixed on Thursday. The urgency is what has happened. The Assam government has not implemented the Bhagwan Patar's judgment and they come up with an OM, no problem. We went on appeal, we win the case. We approached them that now you implement in terms of the division bench order. What they say, you wait for the judgment of Langthasa, that is item number 9. As a result, so lots of promotions are being affirmed. What is the point of coming to the court if we don't get justice in time? What has happened now? Entire petition is being made infructuous because they take a plea, Langthasa is there, we will promote. So what I want, Malat, the item number 3 to 8, your Lordship will segregate it and fix it on Thursday. Malat, I'll satisfy your Lordship.
All the matters will come up.
No, Malat, all will not, because the same submission I made on the last occasion, and on the last occasion, Mr. Chaudhary specifically said 7 will go for a hearing, and that can be sorted. Malat, they don't have any case as regards item number 3 to 9 because we want implementation. If your Lordship doesn't reject my prayer also on the next day.
No, the issue is, Mr. Das.
Yes.
Mr. Chaudhary is there in item 8.
Malan?
Mr. Chaudhary is there in item number 8.
Yes, he is there. He had filed an application for vacation. Malan, Lordship, after the division bench order, when we are coming for implementation, will your Lordship now take up the vacating application?
No, not the vacation.
Yes. He has come up for vacation.
In the main writ petition,
yes.
he is also appealing for respondents 27, 28, and 29.
No, he has pleaded himself. And
whatever it is.
Yes.
But then he's now appearing as a respondent.
Malad, then what I'll say, Malad, if your Lordship is not considering, since your Lordship is fixing on the 16th, on that day.
When do you want it?
16, Lordship, because we have urgency.
16.
Yes, because now what has happened, if your Lordship, because of this delay, they are now going on fully implemented.
What I suggest,
yes,
let us see what I suggest is we list this on 16.
Yes.
On that day,
yes,
if necessary, we'll hear this item 3 to
yes and
8 separately.
Yeah, because yes.
And then 9 onwards.
9 onward, yes. Malad, yes. But Lordship, one thing I like to, since promotions on 2-3 occasions are being given, at least I have had legitimate ground that during this time they will not affect any promotion because that order I can ask. For the simple reason, they are going ahead and they are saying we will not implement the division bench order because 2003 OM is there and your Langthasa's case is, can that be a plea? So I want a protection that I think your Lordship, the balance of convenience is on my side. They will not affect any promotion during this process of 1 week. That part, that's a legitimate prayer.
No such move is there, Lordship, of promoting anybody at this stage. Today he is making the submission.
Malad, I can show through documents. Move is there.
Can I record your statement?
Yes.
As on date, there is no proposal for promoting anybody.
Then your Lordship will record it.
Then I'll record that.
No,
Yes,
Lordship, look what I'm submitting.
But he cannot have video.
He is making this statement in air, Lordship. He has no pleading.
My lord, one thing
No
I like,
pleading,
my lord, if he is sick, then your lordship will take
In
up.
the petition,
But
in
it
the
is not in the air. Well, I don't make
one
submission in
petition
the
he has
air.
filed, lordship.
Whatever.
One petition he has filed, lordship, challenging the OM of 2023. That petition, your lordship is going to heard on
No, that
2016.
is-
Lordship will, if required, lordship will pass any interim order on that day, lordship. Lordship, only after hearing that petition, not now, lordship. That is my submission, lord.
Yes, Majumdar, are you here? Is there any move?
Madam, I may be-
With the
Well,
department.
but
when
I
the judge
deny
is in touch, when he says there is no move, that has to be accepted, madam.
Well, let it be
Because
recorded.
unless he.
Mala, there is an application for stay. If they want to say, then I'll press my stay application.
Madam,
Okay,
Mala.
heard Mr. DK Das, then it comes to the petition. On request made on behalf of Mr. K N Jowdy and the senior counsel. For the respondents, only in item 8, isn't it? Item 8. For the respondents 27, 28, and 29 in WBC 1567 of 2022. List the matter on 16th November. Stop. Para. Mr.
What I'm paying, lordship, as this is his prayer, lordship, just now he made, lordship. Let me also have some instruction on 16, lordship, I have some on
No,
instruction.
what you have said that there's no move. Well,
That
I'm
has to
just-
be
I'm
recorded.
just recording that.
So far as my knowledge is concerned, no move is there.
That
Let
may
me
be
have that
recorded.
instruction, lord. Today is
Mala,
only 16.
Madam, if-
lordship.
Mala, he
If there-
himself is
Madam,
not
let-
sure.
Let me make it clear. If there is any such move, he can always come up with an application that there
No,
is a move.
there is already
up to
there.
Today itself.
The IA is already there. Mala, if he
No, in the
insists, I
IA
can press on the
No,
IA.
Madam, in the IA, if he has indicated about that,
Yes.
let him show, then my learned friend will accept.
Mala, your lordship
IA.
will record
If
that
it is not
this is
there,
his
my lord-
submission.
my lord, if-
Mala, he cannot say
No,
make
if it
two
is not
submission.
there, madam, in the petition, in the IA, if it is not there, right now making a verbal submission, he cannot off the cuff make a.
Then if he
give a
cannot
reply.
make an off the cuff, why is he making a statement that to his knowledge, there is no promotion move?
Yes.
If he is insisting that your lordship should not record, he himself doesn't know what is the government stand.
Grant submission is also not on the basis of any pleading.
No, it is on the basis of
So,
pleadings.
Let him show, lordship. This is the
Well,
law.
No, what Mr. Das says
Yes.
is that they're trying to make some promotion.
100%.
So what you've answered is just no such move, yes or no. Yes
Lordship,
or,
just
Ah.
now he has made.
that's
this-
what I've said.
Lordship,
That's what he
is-
said.
he
You
is
said.
making this submission without any application,
Mala,
without any.
there is an
pleading.
application, my lord. He cannot
Let me
insist.
ask your lord, if your lordship at all intends to record.
My lord, these are the applications.
Let
This will
this
be-
be recorded in 16 lordship. Fixing your lordship is also otherwise. also
And the
he will
higher-
make
No,
this
but by
submission.
16th, if something happens.
Yes,
That's it, lordship, I am appearing, lord.
my lord,
Let me have this on instruction.
my lord, this case is unique on two counts, lordship, which is my duty to inform the court.
Let us
When
not
we
go
moved the
to
first
any
case in
case.
2001, they assured that no move will be there. 3 promotions are there. We have brought everything on record. My lord, this serious violation cannot go unchecked.
Lordship,
My lord, the
even-
government
even
does
one
not
of the
enjoy
petitioner
sovereign
got promoted,
immunity.
lordship.
My lord, the-
Even one of the petitioners got promoted in the meantime. Let him-
Yes, I got my promotion, but I'm challenging the seniority. I'm challenging because once the promotions are quashed, I get my seniority.
Lordship may take it upon 16, as he's saying there is no such move. If in
This
case
is
there
the
is any
case.
such move, they can always come forward with an.
No, no,
Okay, I'll just ensure that
Ensure.
there's nothing going on.
absolutely,
Till 16th.
absolutely.
My
Lord-
prayer will be, lordship may record that he is submitting, he is claiming for one order for recording my statement. Lordship, record my submission that on 16, I will
Let-
have instruction, lordship, record on that day.
Then can I record until 16, nothing will happen?
Absolutely. Well, these are the
Lordship
orders.
may- Lordship is similar, let me be very fair. Lordship simply mentioned that Mr. Nayak has made a submission. That till now, at least there is no such move. That will be subject. That will be subject. Okay.
Mr. P. Naik, then
It will-
standing
for all.
council,
PWD.
PWD submits that there's no move for making promotion at the moment. And therefore, the prayer for interim made by by the learned counsel for the petitioner is not considered today.
Well, is it?
It's not considered today.
Yes, but lordship will record it that the promotions are.
I've said
There is no such.
that there's no move.
Yes.
So
making
during
promotion.
this time, if they do it on the 16th, then again I'll have to press for it.
Once he says there is no such move.
And lordship, this will apply for all the cases because promotions they are trying to promote in all cadres. Lordship will specify. It is not only the PWD department, the government departments also, because there are series of officers who belong to the civil service. Well, this order will apply for all.
That's why I'm saying that there's no move for making promotion
In any of the cadre,
in any of the cadres.
in all the cases.
Lordship, only two cadres are involved. One is executive engineer and one is.
No, my lord, there are, yes, and to the
There's
cadre.
no move for promotion
Even ECS.
in the cadre of executive engineer and
No. Additional chief engineer in PWD, water resource and the civil service. My lord, because we have our own grievance.
It's related to my department.
Yes, then the others might make their submission.
how about
Lordship,
PWD.
regarding water resource department, there is no move for additional chief engineer as of now, Lordship. So far as my knowledge.
So
is
he's
concerned.
maybe
So I
recorded.
am not with the up-to-date
Yes.
information, Lordship. Since my learned senior colleague has not furnished me any copy of the.
My lord, we have
IA.
furnished, we have documents to show. My lord, those things should not be brought here.
I have
I, we have
furnished,
submitted.
So I
Let
am not
us
aware of
concentrate
this,
on the
Lordship.
case.
So Lordship.
so water resources, PWD, there's no move.
Yes.
No, no.
That
As
may
of
be
now,
recorded.
Lordship. As of.
Or
And
else, my
civil
lord, Lordship
service.
can do one, since he's making certain statements here. Lordship may take it up on Monday next. In the meantime, they will bring instruction whether it's a move or not. In
No,
that case,
no,
Lordship will
then
ask
if
for
on
Lordship.
Monday, then I'll start the hearing. My lord, that because lordship had fixed it for a hearing.
Yes, Monday.
Then it's okay.
So
my lord.
Mr. Chowdhury will not be available.
Or not, and Malay on Bihu Day, on Diwali, whether
Monday is a
Mr.
holiday.
Mojumdar will be there, I don't
Tuesday. Monday is
know.
a
Malay, if he doesn't
Monday
want
is
to
a
celebrate
holiday.
Diwali, I don't know.
Monday is a holiday.
Then it's
But he has filed IA only in one case.
No, four cases. Can you don't make such
When
submission?
standing councils appearing for.
We are very thorough in our
Water
case.
resources department submits that there's no move for promotion at this stage.
And the civil service also.
So who appears for civil service?
Yes, government advocate.
ECS.
The government advocate can take same. Yes.
Which item? You are referring to.
Probir Kakure, item number. Vipa, there's two cases, Lordship.
Which one?
Item number
Let us not
12 and
complicate- let us
15.
Not complicate too much.
Yes,
I know.
my lord,
Lordship,
then your
it's
lordship will
correct.
specify all cases. It's not a question of complication, it's my right, which I am vindicating before this court.
Council for the, standing council for the respective departments submits that there's no move for any promotion. at this
Yes.
stage. So accordingly, the prayer for interim made by the learned council for the petitioner is not considered today.
Regarding
It's
what,
on 16th.
Lordship, regarding water resource department, Lordship, there is a move for promotion from junior engineer cadre to assistant engineer cadre.
That is the
That-
concern.
that-
That is the
that might
concern.
not
That is not- I'm
No.
not, why will I go for it? But I am not taking
But
a
Lordship may
license
kindly
to.
specify the promotion regarding the promotion cadre, otherwise the junior engineer cadre will be affected from your Lordship judgment from this
I
order.
don't
Lordship.
think so.
Because
No, that
department
is
will not go.
unnecessary.
Because
Department-
ultimately, your lordship judgment in Langthasa's case will clear the cloud. And lordship, some
From
cases,
additional engineer,
I've got some
additional chief to
benefit.
chief engineer, that cadre will not be promoted. That is.
my lord, one
Lordship
thing,
may kindly specify, Lordship.
well, I am withdrawing certain matters. I have instruction because we have got the relief. Item number 10 and 11, we are withdrawing. We are not pressing, rather. Item number 10, Turung, Pranab Kumar Turung. My lord, he has already got his benefit.
Then and
Water resource, Mr. Das is there. And item number 6, Bharat Chandra Das, he has retired, and 18. So total
Six.
4 cases, 6 and 18, 10 and 12, 10 and 11. 6, 10, 11, and
pass
18.
separate orders in all this item number
You know,
six,
this case may be brought.
10, 11 and 18. Mr. D.K. Das, learned council for petitioner submits that the petitioner has got.
6, 10, 11.
He has instructions, not the press. Accordingly, the petition is
আমার miss case
disposed.
আছে, না?
Same orders.
Well, since a submission has been made that we have no miss case, well, those miss case may be brought on record, Lordship.
When did you file it?
Well, we filed it before the 12th
Of October.
October we filed. We could check it from the registry. They,
Is it a miss case or an IA?
no, it's an IA.
Interlocutory.
What is the,
This is this,
what is the number?
no, we have not got the number. We contacted the registry. They said since all matters have come up, they could not send the IA.
So let it come.
Yes, yes.
It will come.
No, no, the submission was made that no IA was there.
Whatever it is.
Obliged, Lordship.
19.
Please, your lordship. By the order dated 27/9/2023, this honorable court was pleased to fix the matter for admission hearing. This is a matter with regard to compassionate family pension. What happened in this matter in the year 2008, the respondents issued an advertisement. My lord, I participated in the selection process and I appeared in the interview, viva voce and the written examination, and therefore I was got selected for the post of, my lord, LD assistant, my lord, junior assistant.
Where's the advertisement?
Advertisement was issued on 5/3/2008. That your lordship will find page 29.
Yes.
Lordship will see applications are invited from Indian citizen of male, female deserving candidate with duly filled standard so and so, so and so, so and so, and filling up of the vacant post lying in council, head of the department, offices, district and sub offices of BTC area as per the details of post given below. Junior assistant, LDA, grade 3. That was the post. My lord, the petitioner, he submitted his candidature and accordingly, lordship will kindly come to page 33, annexure P2.
One minute. Yes.
Pursuant to this advertisement, my lord, the petitioner's husband, he submitted his candidature and call letter of the examination, your lordship will find page 33. Call letter for written examination, junior assistant, Manik Chandra Roy. He was the husband of the petitioner. With reference to your application to Central Selection Board BTC for the post of junior assistant, you are hereby directed to appear in the written test as per program below. So 28 September 2008 was the written test, and roll number of the petitioner's husband, your lordship will find at serial number 9. Within that block, roll number in top also, lordship will find JRA 2285. Now, my lord, lordship will kindly turn to page 34, my lord.
Yes.
He was called for interview. He was called for interview. Then, if your lordships kindly turn to page 35, this was a communication issued by the member secretary to the Secretary Personnel Department BTC. With reference to the subject cited above, I am directed to submit herewith the approved list of selected candidates for the post of junior assistant stroke LD assistant, for which written test was conducted on so and so, viva voce on so and so, under the Central Selection Board BTC respectively. Now here, page 36, the husband of the petitioner, Manik Chandra Roy, he was selected, my lord. These are the type copies, my lord. Original copy, my lord, will find page 37 and 38. Then, my lord, this order came, page 39. There where the, my lord, entire thing turned around. Here, if your lordships kindly see, in pursuance to the letter dated so and so, so and so, so and so, the following persons, third line, my lord, right hand side, the following persons are hereby appointed as junior assistant stroke LD assistant on fixed pay of rupees 5,200. Lord, it was a recruitment for, it was a regular recruitment for filling of the sanctioned vacant post. And interview, written examination, everything had happened. The petitioner's husband was selected, and thereafter they were posted on fixed pay, 5,200. He joined in this post, my lord, because he had, and his name was there at page 42, serial number 28.
Yes. Yes.
Serial number 28, husband, Manik Chandra Roy.
Then what?
Then my lord will kindly come to page 43. This was the order. In pursuance to the letter number so and so, so and so, so and so, from the Joint Secretary Transport Department, BTC, the following persons are hereby appointed as junior assistant on fixed pay of rupees so and so only per month with effect from the date of joining duty. Down below, my lord, the petitioner's husband's name is there. Then page 45 is the joining report. He continued in that post since the date of joining, my lord. Since 2011, he continued in the post of junior assistant on fixed pay, my lord.
Yeah.
Although he should have been appointed in a substantive post with substantive pay, he was kept in a fixed pay, he continued. Thereafter, in the year 2018, page 46, my lord will find, they have undertaken some exercise and they say, I am directed to state that the Boredal Territorial Council is pleased to approve for appointment of the following 7 numbers of fixed pay employees of entrusted department of BTC in the vacant section post as indicated below under the Water Resource Department in Kokrajhar, Baksar District BTC as per the decision of the Executive Council meeting of the BTC held on 4th September 2017. Now in this list, the name of the petitioner, your lordship will find page 47, serial number 1.
Yes.
So what they did, my lord, they conducted a regular recruitment process for candidates selected, appointed him on fixed pay, kept on continuing with that from 2011 to 2018. 2018, they have come up with a stand that these persons are now appointed as against the vacant post. Although that time also the posts were there. Without any post, how can you make a recruitment? Now, your lordship will find page 48. He was appointed as section assistant by this order. In pursuance to the additional principal secretary, Boreal Territorial Council, Kokrajhar, so and so, so and so, so and so, for filling of the post of discharge without notice and without assigning any reason thereof, and the subject of satisfactory police verification report, following fixed pay employees are hereby appointed as section assistant against vacant post in pay structure so and so, so and so, plus other allowances as admissible under the government rule so and so. The name of the petitioner at serial number 1, my lord.
Yes.
Then page 50 is a order by which he was once transferred to another place, page 50, my lord. Then on, my lord, 7/12/2018, the husband of the petitioner, that is Manik Chandra Roy, he died, my lord. Death certificate, your lordship will find page 52. Then page 53 is the next of kin certificate issued by the government.
Yes.
Page 53, your lordship will file serial number 1 is the petitioner. Serial number 2 is the daughter, 10 years old. Serial number 3 is 5 years old daughter, my lord. Then page 54 is the scheme for compassionate family pension, my lord.
Yes.
If your lordships kindly come to page 55. Para 5.3, my lord.
Yes.
Where the employee dies before superannuation, the family pension equal to 100% of last pay drawn by the deceased employee be paid for a period up to the date of deemed superannuation of the deceased employee, i.e. the date on which the employee would have superannuated had he been alive. This would compensate the loss of family income to a large extent and fulfill the requirement of compassionate conditions arising out of the date of the serving employees. However, the government must complete minimum 1 year of government servant must complete minimum 1 year of continuous service without break before death while in service.
1 minute. When were you appointed regularly?
Appointed regularly, joining report 28/2/2011, my lord. 26/7, my lord, sorry.
Yes.
17/7/2018 is the approval, 26/7/2018 is the order of appointment.
Yes.
Now, what they are harping is that, my lord, since this para 5.2 subparagraph, it says that 1 year, there has to be 1 year service, they are wiping out my entire service from 2011. And they are saying that from 2018 till my death, there is lack of less than 1 year service. So I am not entitled for compassionate family pension. That is their whole case, my lord. And the order passed by the authorities, then thereafter, my lord, page 59 is the representation submitted by the petitioner. Page 60 also representation submitted by the petitioner praying for family pension. Page 61 is the detailed representation submitted by the petitioner. Wherein at para 2, she stated that her husband joined as in the year 2011, and although he should have been appointed as regular employee, but he was kept in fixed pay. Then, my lord, they have passed the order that your lordship will find issued the communication, page 65.
Yes.
May I read, my lord. This was a communication issued by the executive engineer, Baksa Water Resource Division, to the principal secretary, Boroland Territorial Council, regarding compassionate family pension and other benefit in respect of Sri so-and-so, so-and-so, so-and-so. Sir, with reference to the subject cited above, I have the honor to state that Sri so-and-so, ex-section assistant of Baksa Water Resource Division, Mosalpur, expired on so-and-so after rendering service with effect from 26/7/2018 to 7/12/2018, 4 months, 12 days. He appointed as section assistant, right office memo dated so-and-so, so-and-so. In this connection, it is also to inform you that Manik Chandra Roy, ex-section assistant, worked in fixed pay at the rate of rupees 5,200 per month as junior assistant in the office of the Junior Joint Commissioner of Transport, BTC, Kokrajhar, since 28/2/2011 till joining as Baksa Water Resource Division, Mosalpur, White order date so-and-so. Within bracket, they say fixed pay is not pensionable service as per rules. Let so-and-so, ex-section assistant, has no NPS during his short span of regular service period, and hence no subscription was deducted from the salary for NPS, and only group insurance scheme 200 per month deducted with effect from so-and-so to so-and-so. Now an amount of rupees so-and-so only being the insurance fund under group C, and also an amount of rupees so-and-so earned leave salary for 10 days only have been sanctioned right office dated so-and-so. In this context, it is to inform you that there is no provision in compassionate family pension scheme for those who expired before completion of 1 year of regular service, right notification dated so-and-so. Clause 53, where in the circular stated that the government servant must complete minimum 1 year of continuous service without break before date file in service. I therefore request your honor kindly to look into the matter and put your valued advice whether benefits may be allowed or not to so-and-so, so that the undersigned may take further action. Then your lordship will kindly come page 66, my lord. Para 2. As per instruction of Senior FA BTC Section Secretariat, Kokrajhar, the applicant doesn't come under compassionate family pension scheme as late ex-SA has not completed 1 year of completed service period. A person must be completed minimum 1 year of service for CPF scheme. CFP is paid by all Assam recommendation of state government. Then another representation was filed, page 67, 21/11/2020.
Yeah.
Then, my lord, lastly, page 69. By this communication, the executive engineer again wrote to Chief Engineer, Water Resource Department, narrating everything. Lastly, I therefore request your honor kindly to look into the matter and put your valued advice whether pensionary benefit may be allowed or not to so and so, X so and so that the undersigned may take further necessary action. Now, the entire question that boils down is that whether that period from 2011 to 2018 will have to be counted while calculating qualifying service of 1 year for the purpose of compassionate family pension. If your lordships kindly see the scheme again, what does it say? Page 55, second paragraph.
Yes.
It says, however, the government servant must complete minimum 1 year of continuous service without break. The requirement under the scheme is continuous service without break.
Yes.
So there was no break in service of the petitioner. It was a continuous service since
Let us see
2000.
your advertisement once again.
Advertisement?
Yes.
Yes, ma'am.
What does it say?
Yes. Page 29, my lord. Applications are invited from Indian citizen of male, female, deserving candidates with duly filled in standard form affixed with 2 recent passport size photograph with attested copies of editorial qualifications, etc. for recruitment and filling up of the vacant posts lying in the council, head of department, office, district, and subdivisional offices of BTC area as per details given below. Serial number H, the candidates who are already engaged to the office of so-and-so on fixed pay basis by the BTC, either grade 3, grade 4, also need to apply. Candidates, applicants who are BTC Secretariat Office on fixed pay basis, either on grade 3, grade 4 may also apply, as there is no sanctioned post in BTC Secretariat Office at present. So,
The issue is you accepted this appointment, isn't it?
the issue is, my lord, they issued an advertisement for filling up of the post. My lord, regular sanction post, my lord.
Sanction board is not. Sanction board is not there. I can not.
All right, fine, my lord. The vacancies are there. They issued an advertisement. I appeared, I participated, I submitted my candidature. A written examination was conducted. I appeared in the written examination. Thereafter, my lord, interview was held. I appeared in the interview. I was selected.
That's fine.
Thereafter, the process should
The
have been.
advertisement is silent whether it is sanctioned post. It is silent.
Yes,
It
ma'am.
only says it's the vacant post.
Fine, my lord.
Correct.
Fine.
Then you were given the appointment on fixed pay
What they should have done,
of 5,000 something.
yes, 5,200.
You accepted that appointment.
I had a lesser bargaining option, my lord. I don't have any option. I participated in a selection process. I cannot say them that you give me appointment on this post or that post. But my lord, when a regular recruitment is held for filling up of certain vacant posts,
No. You cannot say this is a regular recruitment process.
my lord, this is a regular.
Reading of the advertisement clearly indicates that it's an advertisement for some vacant post.
My lord, sir, vacant post is a regular recruitment, my lord. It's not a contractual or fixed pay recruitment process. This was not a fixed pay recruitment
The
process.
advertisement is totally silent on that aspect.
Fine, my lord. But the posts were there. My lord, what I am trying to emphasize before your lordship. My lord, what is the requirement? Because we'll have to go by the scheme formulated by the government of Assam in 2017. What is the requirement of the scheme? Scheme says continuous service.
Oh,
It doesn't say that my service has to be against the sanctioned post, vacant post, or anything else. It says that I have to be in a continuous regular service. If your lordships kindly come to the scheme again.
Where's the scheme?
However, there is no dispute about the fact that I am not a government servant. I am a government servant, my lord. Page 55. And ultimately, my lord, these are all beneficial legislations for the welfare of the family after the person is deceased. Second paragraph. However, the government servant must complete minimum 1 year of continuous service without break. The requirement is continuous service without break of a government servant. They don't dispute that in 2011 I was not a government servant. So the requirement is not that I have to be in continuous service in a sanctioned post or something like that. The requirement is, Lordship will kindly appreciate, these are all beneficial legislation. These are come so that the family of the person, because this is in lieu of compassionate appointment scheme. Government has discontinued the compassionate appointment scheme and come up with this that will give compassionate family pension to the family after the person is died. Now, it says that a person has to be in continuous service without break. There should not be any break. There is nothing in the pleadings or from the affidavit of the respondents that there was in break in service. I continued from 2011. In 2018, you have taken up some process and give me a pay scale. My service continued, my lord. There was no break in service. So in that view of the matter, that period has to be counted while calculating qualifying service of 1 year for pension. Otherwise, a person cannot my lord, think of a situation that I'll die after completing 1 year. That is also, my lord, although it's not, my lord, that can also be appreciated. A person cannot presume his death, that my family will get family pension, so I'll die after 1 year of service, my lord. He died, my lord. It was an unfortunate incident. 2 minor girls, 10 year and 5 year, my lord. How the family will survive? That is on equity, my lord. But if we go by the scheme on the face of it, it is absolutely clear. They filed affidavit. Your lordship will kindly see the affidavit filed by the respondents. Two affidavit they have filed.
Who has filed?
One in 2000.
Respondent number 5.
Yes, respondent number 5, that is 29/3/2022.
Correct.
Same stand. In fact, page 5, they go one step ahead, my lord. Page 5, the paragraph which starts as it is specifically stated that your lordship will find it is specifically denied that by this deponent the petitioner was kept in fixed pay since 2011 to 2018. Has your lordships got, my lord?
Yes.
They even deny my that service also. But record speaks for itself, my lord.
Yes. Yeah. Where's the other affidavit?
There is another affidavit that was filed on 29/3/2023. This was by respondent number 7.
Yes.
Same thing, my lord. Para 6, they say the approval for appointment of so-and-so, husband of so-and-so as fixed pay employee as section assistant was issued by the additional principal secretary BTC Kokrajhar as per decision of the executive council meeting held on so-and-so. Then your lordship will find page para 11, my lord.
Compassionate Family Pension Scheme is applicable to those employees who died in harness on or after 1/4/2017 as per clause so and so. The government servant must complete minimum 1 year of continuous service without break before that while in service as per clause 5.3.
Yes.
So this is their stand. They say that I don't complete, the petitioner's husband did not complete 1 year service, short of 1 year service, so not entitled to pension. But the authorities fail to appreciate this aspect of the matter because the scheme says continuous service. It doesn't say that my service has to be in a sanctioned post, vacant post. No such differentiation has been made. It only says continuous. If my service is continuous, the impugn order or impugn communications nowhere stated that there was discontinuation in service or break in service. The affidavit also doesn't say anywhere that there was break in service. So in that view of the matter, this period has to be counted to meet up this remaining period of service. 4 months, 12 days, the petitioner's husband was there. The remaining service can always be counted to give benefit of pension to this poor lady and the small kids, my lord. So for that, my lord, I'm just relying on a few judgments, my lord. One of the judgments, your lordship was also, lordship's judgment is also there. Even there are decisions of this honorable court that the muster roll service of a employee after regularization, that period is also counted for the purpose.
Yes.
My lord will kindly take a first judgment, my lord, that is 1996 7 SCC 113. My lord, I'll only, this is a small 2-page judgment. Para 3, my lord. Almost identical situation had occurred in this case. Dr. So-and-so, learned senior advocate appearing for the Union of India, has contended that on so-and-so, when the appellant was prematurely retired, he had put in 18.5 years of quasi-permanent service. According to him, to earn pension, it was necessary to have a minimum 10 years of permanent service. It is contended that since the total service of the applicant was in quasi-permanent capacity, he was not entitled to the pensionary benefit. There is nothing on record to show as to why the appellant was not made permanent, even when he had served the government for 18.5 years. It would be travesty of justice if the appellant is denied the pensionary benefits simply on the ground that he was not a permanent employee of the government. The appellant, having served the government for almost 2 decades, it would be unfair to treat him as temporary or quasi-permanent. Keeping in view the facts and circumstances of this case, we hold that the appellant shall be deemed to have become permanent after he served the government for such a long period. The service of the appellant shall be treated to be in permanent capacity and he shall be entitled to pensionary benefit. Now here, my lord, he served 18.5 years. Government should have made him permanent, but did not do it. And thereafter took a stand that his service was quasi-permanent. In that event, Supreme Court made it deemed that we deem that his service is permanent and give him pension. Herein also, my lord, when I participated in a selection process, again, vacant post, my lord, the idea is that I will be appointed in a vacant post, appointed in that particular post, and I will be given a pay scale. Why you did not give the pay scale? You should have given a pay scale when you have undertaken a regular recruitment process, or you have undertaken selection for the post of vacant post, selection for the post of vacant post. The advertisement doesn't say that it was for fixed pay employees only. The appointments will be made on fixed pay, doesn't say. And clause 7 and 8 of the advertisement, Millard gives a rider. It says the fixed pay employees can also apply. What does it mean, Millard?
clause 7 and 8 of the advertisement says that fixed pay employees who are working in other departments, they can also apply. Meaning thereby, this is a regular recruitment process. All who are working in different offices in fixed pay, you also apply in this advertisement.
Yes. Then next case.
Then my lord will kindly have a look. Next, 2004 3 GLR 211. Lordship's got my lord.
Yes.
Yes. I'm relying on para 3, 7, 10, and 11. Para 6, my lord, will kindly have a look. It will give give an idea about the objections raised by the respondents, my lord. Though no affidavit has been filed, Sri so-and-so learned standing counsel produced before this court the para-wise comments furnished by the Director of Elementary Education, Assam. The stand of the state respondents appeared to be that the petitioner's service rendered under so-and-so was not pensionable at the relevant time, and that process has been initiated for making it pensionable as reflected in the letter dated so-and-so. The plea taken is that as the service rendered by the petitioner while posted at so-and-so with effect from 1/6/95 till his retirement through pension, though pensionable, is less than 10 years, his pension has been held up for the time being pending a final decision. Para 7. So so-and-so learned counsel for the petitioner in the above factual premises has submitted that in the facts and circumstances of the case, the stand of the state respondents that service rendered by the petitioner under Karbi Anglong Autonomous Council is not pensionable is wholly untenable. The appointment of the petitioner having been made admittedly against a government sanctioned post and he having served continuously for about 37 years, being granted a permanent status with fixed pay by the government from time to time, the impugned action is patently illegal, arbitrary, and discrimination. Then my lord will kindly come para 10. Admittedly, the appointment of the petitioner in the year 1963 has been against the government sanctioned post. There is no denial of the fact that the pay of the petitioner was fixed by the government from time to time and that the petitioner was granted a permanent status in the course of his service. His pay was released by the council during his tenure under it was made from government funds. There has been no break in service in 1963 till his retirement in the year 2000. Having regard to the materials on record and stand of the parties, I am of the view that service rendered by the petitioner from 1963 to 1995 under so-and-so till he was transferred to so-and-so should be construed to be pensionable service for entitling him for his pensionary benefit under the Assam Service Pension Rules 1969. In my considered opinion, all the conditions enumerated in Rule 31 of the said rules for receiving pension are satisfied in the instant case, and there appears to be no impediment in law to release the pensionary benefit to the petitioner. So here it says that even if he was on a fixed pay, that service was recognized. He was paid from the state money. And although he was transferred from one school to another school, there was no break. So that period has to be counted as pensionable service.
Yes.
Then my lord will kindly come 2003 1 GLT 523. Lordship's got my lord?
Yes.
Yeah, I'll directly take your lordships to the relevant portion, para 4, my lord. Down below, your lordship will find second page, para 4. May I read, my lord? Upon hearing Sri so-and-so learned counsel appearing for the petitioner and so-and-so senior government advocate as well as on perusal of the materials on record, I am of the view that the petitioner has enforceable legal right to get the pension in the instant case for the following reasons. The law has been well settled on the related issue by this court in connection with the entitlement of pension. In Kobiram Rajbangshi versus State of Assam reported in so-and-so, this court examined as to whether the petitioner in that case would be entitled to pension holding his date of entry into service from 1972, though he did not render qualifying regular service of 10 years. And in that case, this court held thus. Keeping this background of law in mind, I allow this writ petition and direct that the petitioner shall be entitled to pension, and for that purpose, the authority is directed to make necessary declaration as provided under the proviso to Rule 31 as quoted above. This declaration shall be made within a period of 1 month from the date of receipt of the judgment, and order and pension of the petitioner shall be computed according to this entitlement. In an unreported judgment of this court rendered in so-and-so, this court made the following observation. In the case in hand, the petitioner is all along served under the government for more than 35 years of continuous service. He served as regular master roll worker for 9 years, 2 months, and was confirmed at last stage of his service, i.e. on 1/1/1993. By judgment dated so-and-so passed by this court in civil rule so-and-so, as well as civil rule so-and-so, held that the master roll laborers is entitled to pension, and for the purpose of earlier period prior to confirmation is to be computed for the purpose of pension, qualifying the service period. Hence, this case also squarely covered by the aforesaid decision in the light of the above decision as well as the government policy indicated above. Respondents is directed to make necessary declaration under Rule 31 of the Assam Service Pension Rule 1969 and to complete the above exercise within a period of a month from the date of receipt of this order. Similar view was also taken in another case between so-and-so. Similar in a case between so-and-so. This court further reiterated that a muster roll worker, after serving for 18 years long service, was regularized in service, but he served for a little more than 5 years in regular capacity before reaching the age of superannuation. And the authority concerned denied pension to said muster roll worker on the ground that the said muster roll worker did not complete 10 years of pensionable service in regular capacity. And in that case, this court held that said muster roll worker was entitled to pension. In view of the aforesaid settled position of law, I am of the opinion that the present case is covered by the aforesaid decisions of this court, and accordingly this court need not go more into depth as suffice is made to make the following order and directions. The impugn order dated so-and-so, issued by the so-and-so, are hereby quashed with a direction. So sum and substance is that, my lord, if a muster roll period of service is to be counted as qualifying service for pension, my lord, I am in a much better footing, my lord. I came into service by way of a selection process, my lord. Next is, my lord, your 2018 4 GLT 1110. Although this is a matter pertaining to compassionate appointment, my lord, para 8 I am relying for a moment, my lord. Because some similarity is there, my lord, in compassionate appointment and compassionate family pension. In, my lord, understanding the ratio. Para 8 down below, second page down below, your lordship will find a proper reading down below, my lord. A proper reading of the OM dated so-and-so would clearly indicate that the new pension scheme is made mandatory with effect from 1/1/2004 only to those new entrants to the service of so-and-so. Further, clause 1 clearly indicate that the new scheme is mandatory for those employees joining after 1/1/2004. Coming to the case in hand, it is undisputed that the petitioner's husband was appointed as early as 1/2/1984 as muster roll worker and was thereafter regularized as so-and-so by order dated 2005 and with effect from 1/6/2005. This would indicate that on 1/6/2005, that is the date of regularization of petitioner's late husband, he was not a new entrant to the service of the respondents. It was only a case of regularization into a regular vacancy. The petitioner's late husband had in fact joined into service of the respondents as early as 1/2/1984. Therefore, this court is of the considered opinion that the new pension scheme as adopted by OM dated so and so is not applicable to the petitioner's late husband. And in that view of the matter, it is declared that the petitioner is entitled to family pension from the respondents. Consequently, the petitioner is also entitled to receive DCRG as well as DIS accordingly writ petition allowed. So here was also, below whether he will be under the new pension scheme or old pension scheme, whether that period will be recognized or not. That was the question while considering the facts of that case. In that event, this honorable court has held that that period has to be counted. Now, there is another judgment, that is writ petition number 3413/2021. Abdul Haq Chaudhary versus State of Assam, it's 3-page judgment, Milord. I'll just take your lordships to all the paragraphs. Para 2, my lord. The petitioner was appointed as casual employee contingent on a fixed remuneration of so-and-so per month with effect from 1993 as per the order of Chief Judicial Magistrate Kachar dated so-and-so. Subsequently, the service of the petitioner stood regularized as per the order dated so-and-so of CJM Kachar, and thereafter he retired from service on 31/10/2020. The grievance raised in the petition is that the pensionary benefit of the petitioner had not been paid. In this respect, a communication dated so-and-so of the senior accounts officer in the Office of Principal Accountant General Assam has been brought to the notice of the court, which provides that as per the Assam Service Pension Rules 1969, an employee should have minimum 5 years to earn gratuity, and for the purpose of pension, one has to put in minimum 10 years of qualifying service. The communication further provides that as the petitioner had joined his service on 18/11/2015 as peon upon being regularized and retired from service on 31/10/2020, he has completed 4 years, 11 months, 13 days of service. It is also provided that as per the new pension rule, which came into effect from 1/2/2005, the petitioner would now be governed by the new defined contributory pension scheme and not by the Assam Service Pension Rules 1969. We take note that the petitioner was initially appointed as casual employee on 1/11/1993 and was regularized by order dated 18/11/2015 and retired on 31/10/2020. In respect of such casual worker, master roll workers who have been subsequently regularized, their entitlement for pension is governed by another set of laws as provided in OM number 96/2009, which provides that the work charge and master roll employees who are regularized after 1/2/2005 would not be governed by the new defined contributory pension scheme, but by the existing Assam Service Pension Rule 1969. Further, we take note of the judgment of this court rendered in Sanjita Roy versus State of Assam and others, reported in 2019 2 GLT 805, wherein it is provided that 6 years of qualifying service of an employee as a master roll worker cannot be excluded for the purpose of arriving at the qualifying service for pension. The said judgment also impliedly provides, this is important, Miller. The said judgment also impliedly provides that the entire service of a master roll worker from the date of his initial appointment up to the date of his retirement should be taken into consideration for the purpose of qualifying service for entitlement for pension. In view of above, the communication dated so-and-so, senior accounts officer in the Office of Principal Accountant General Assam is set aside and matter is remanded back so-and-so.
Yes.
Milord, Sanjita Roy, Milord, I have given a copy, Milord, para 29. Wherein, Milord, this issue came whether 6 years service can be cut off from the service of master roll worker. Milord, that was interfered. Para 29 and 31 I am relying on, Milord.
Yes.
Milord, in between, I'm just reading the relevant portion. In between, Milord, there is a line. It will be wholly unfair. Round about, Milord, 1, 2, 3, 4, 5, 6, 7, 8, 9. 10th line from below in para 29. It will be wholly unfair and unreasonable to deny a master roll worker who is admittedly completed 20 years of continuous service of pension in terms of office memorandum dated so-and-so. However, deduction of 6 years or for that matter, any period to calculate 20 years of continuous service does not appear to be reasonable. Deduction of 6 years and for that matter, any period, this honorable court has held, not only 6 years, any period, then my lord, para 31 is the directions, my lord. My lord, I'll just continue in that para 29, my lord. The entire exercise of issuing the notification should be in a positive manner so as to ensure that the maximum benefit is given to the incumbents who undoubtedly belong to the economically lower strata of the society. It should have been endeavor of the state not to make a further classification of the muster roll workers who have completed 20 years continuous service by introducing the condition of deduction of 6 years of casual service. Admittedly, there is no difference between them, between the service rendered by the petitioner while they were employed in a casual manner or after regularization. Now, para 31. In view of above discussion and taking into consideration the various judicial pronouncements on this subject, the writ petitions are disposed of directing the respondents authorities to determine the continuous service length of the petitioners as a muster roll worker, and if such service meets the benchmark of 20 years without any deduction, the benefit of pension should be made available to them. While carrying out said exercise, the respondent authorities are directed to take recourse to Rule 67 for those petitioners who fail to meet the benchmark of 20 years by 12 months or less. Now, one last judgment, that is 2019 6 SCC 647. Lordship will kindly take the last page of this judgment, my lord. This I am placing only to demonstrate before your lordship what is continuous service. Because scheme says continuous service, it is a part of para 9, my lord.
Para 9.
Para 9 of this judgment, I am just taking your lordships directly to the relevant portion, my lord. Third line, my lord. In the recruitment rules, continuous service is not defined. Therefore, one has to consider the ordinary dictionary meaning of continuous, which means uninterrupted and unbroken. The High Court has added the word actual, which as such is not there in Appendix 9. While considering the relevant provisions and as per the rules of interpretation, when the language used is unambiguous, plain and simple, the provision is required to be read as it is and nothing is to be added. Therefore, when in Appendix 9, the eligibility criteria is that no person shall be eligible for promotion unless he has completed service for a continuous service of not less than 3 years, means he has to render complete service for a continuous period of uninterrupted, unbroken 3 years service. Therefore, when respondent number 3 had not completed 3 years of continuous service of not less than 3 years in the feeder category of so-and-so, he was not eligible for promotion to the post of section officer. The High Court has committed a grave error in holding otherwise. So, in my humble submission, my lord, the continuous service is my humble submission. The meaning of continuous service is continuous uninterrupted service, my lord, which doesn't have any break. You cannot give an additional meaning to that by adding sanction post, vacant post, whatever else. When the scheme doesn't say that it has to be a sanction post or substantive service or anything sort of those words, you cannot change it. It's a continuous service. I was in the year 2011, I was in government service. You did not post me giving a fixed pay, giving a regular pay scale. That is not my fault. When I appear for an interview or an examination for a vacant post, the expectation of the candidate is that he will be appointed in a post having a pay scale. You post me in a fixed pay. I did not have any bargaining option, my lord. I am a candidate. I'll have to accept whatever is there. I was in a lesser bargaining option. So I accepted that. I worked. Thereafter, you brought me to a pay scale in 2018, and I died after 4 months of service. So my humble submission is that when you are you have circulated a beneficial legislation which is for the care and sustenance of the family of a deceased person after his death. You cannot give such a narrow interpretation to the word continuous service to deny benefit of compassionate family pension to this poor lady and these two poor children, my lord. 10 years and 5 years, my lord. That is my humble submission before your lordship. Deeply obliged.
Lordship, in this case, I am appearing for the PTC authority, Lordship. I am the administrative department. Lordship will hear my submission on Thursday.
What?
Thursday, Lord. He has made extensive submission, Lord. No reply was filed to my affidavit. I heard his submission, Lord. I will make my submission on Thursday.
Why not today?
Lordship, some judgment he placed on. All those judgments relating to pension, not family pension. So there is a basic distinction between pension and family pension. On that point, Lordship, I would like to place certain judgment. That is one. Secondly, Lordship, he is repeatedly pointing out the scheme, Lordship. Page 55. The vital word, my friend, is knowingly suppressing his Lordship, a government servant. Who is a government servant? Continuous service is okay, but who is a government servant? That one, Lordship, I'd like to.
Miller, one thing, my friend, let my friend answer, but that was not the ground in the impugn communication, nor a ground in the affidavit, Miller. They cannot improve their case. MS Gill, Miller. That was never a ground that I was not a government servant. So that's why compassionate family pension will not be given to the petitioner, Miller.
Ultimately, my friend is claiming certain benefit under a particular scheme. That will be my submission. On Thursday, Lord.
But Mr. HK does. On request made by Mr. P. Nair, the standing council, BTC.
BTC, Lord.
List the matter again.
As part of Lordship has heard substantially.
There may be some difficulties.
It's Thursday only in this week.
Thursday, Lordship may keep it.
Bench may change.
Even then, Lordship will keep as part of, since Lordship has heard, wherever your Lordship is there,
Lordship.
the matter will come up before your Lordship.
Yes, as part of.
Yes. Highly obliged.
Obliged.
21.
May I please, Your Lordship?
Yes.
Okay, kindly peruse the last order dated 21/9/2023. Matter relating to non-payment of some area salary, Lord.
Yes.
But in fact, the issue involving this case has already been decided. by this honorable court in another round of litigation, that is page 34, your lordship will find. 34.
My lord, in this regard, we have received one instruction here, my lord. Petitioner did not receive his salary despite of previous joining of Deorali title Madrasa because of the reason of non-issuing of last paying certificate from the Asima Senior Madrasa as reported by the principal, my lord. So the petitioner has not received the last paying certificate. So this is the reason, my lord, for non-payment of, and the government therefore requested to issue necessary instruction on the matter, release of arrears salary as a claim by the petitioner in the above.
So matter may be disposed of, lordship, in terms of that.
What is it? Let us.
My lord. Yes, isn't it?
Yes.
My lord, if your lordship, kindly come to page 37. It starts from 37, 34. Your lordship will clearly understand the position of this case. Lordship, page 37.
Yes.
From the opposite aspect, we are of the view that the transfer order dated so and so requires an interference, and accordingly the same instant is set aside. The implication thereof would be that Sofiqul Islam Chaudhary will continue as LDA of Deoral Title Madrasa, and Muhammad Sadiq Ahmed, he is the petitioner lordship, will continue as LDA of Asimia High School, which was earlier called Asimia Senior Madrasa. However, as the transfer order is a prerogative of the employer, liberty remains with the authority if the causes arising in the public interest to take decision as deemed to be required. It is stated that Sadiq Ahmed, the petitioner of in WBC number so and so, in view of the interim order of the court dated so and so in WBC number so and so, was subsequently transferred to another school, namely Anwarul Ulum Senior Madrasa. As the order dated 8/11/2019 was passed as a consequence of the interim order dated so and so, we also interfere with the said order and set aside. Now, lordship, this is important. The implication of setting aside the respective transfer orders would be that the authority would have to consider that both the petitioners were continuously in service in their respective post, and therefore respective salary should be paid. So after that, lordship, page 39 order was passed. In compliance of the Honorable High Court order dated so and so, passed in so and so, in pursuance of government letter so and so, cancelling this office earlier order issued number so and so, Sadiq Ahmed, LD assistant, is hereby allowed to continue his service in his original place of posting at Asimia High School and erstwhile Senior Madrasa under Korimbganj district in his own grade and scale of pay with effect from 11/6/2019.
Now
So-
now he is doing the job.
Yes, Lordship, he is getting salary from March 2021. But the period from 1/6/2019 to 28/2/2021. 28/2/2021 has not been paid. Subsequently, Lordship, the Inspector of School Lordship has submitted the proposal, that is page 42. Proposal for area salary along with non-burial certificate. Page up to 45, Lordship. To the Director of Secondary Education. Assam.
Page 42.
42, this is the forwarding of the Inspector of School. Area salary proposal. 43, 44 is the non-burial certificate.
Yes.
Countersigned by the Treasury Official. 44. And statement showing the requirement of the area salary, that is page 45.
Yes.
So direction may be given, Lordship, to release the salary, Lordship, as the Director has already made a communication to the government, Lordship, for a necessary issue.
In view of this instruction, the government is therefore requested for necessary instruction regarding the matter releasing the arrears salary.
Then what
Yeah.
instructions do you have from the government?
From the government, I have not received the instruction yet, my lord. It is from the director. And I requested, director.
This is a
requested-
letter requesting for instructions.
Yes, my lord.
What instructions have you given? This was of 5th October 2023.
Yes.
More than 2 months, maybe 1 month.
My lord, last opportunity may be given to the secretary for regarding the instruction.
Okay, but Mr. Ayub Khan, let us consider the petition. On the request made by Mr. Yu Sharma, let us. Standing council,
For secondary education
Secretary
department.
Education Department. List the matter out.
After 4 weeks, my lord.
No.
Why 4 weeks?
Three weeks.
Already one month is gone. I'm giving you 2 weeks.
3 weeks, my lord.
On 23rd. Lordship.
Yes, list on 23rd. You enable him to receive instructions.
23.
May I please your lordship. Lordship, the matter relates to proportionate pension, lordship. The petitioner, being a head constable, served under the central government scheme, namely prevention of infiltrators of foreigners, lordship. He served more than 17 years, 2 months and 26 days. But due to some asthmatic problem, he could not serve continuously. So after serving 17 years, 2 months and 26 days, lordship, he is eligible for proportionate pension. The petitioner filed an application, lordship, will find at page 41, lordship. The petitioner filed an application for paying proportionate pension to the Superintendent of Police, Border, Assam, lordship. And the petitioner annexed and after receiving that application of the petitioner for proportionate pension, lordship, the respondent, the Superintendent of Police, replied, lordship. The Superintendent of Police recommended the application for proportionate pension of the petitioner to the Deputy Inspector General of Police, Lordship. Lordship will find at page 42, Lordship.
Yes.
Lordship, at page 42, the Deputy Inspector General of Police, in the last paragraph, in view of the above, necessary instruction clarification is solicited as to whether head constable so-and-so, the petitioner is eligible for proportionate pension and other retirement benefit as per Gov. OM, so as to take further necessary action at this end, Lordship. And Lordship, the Deputy Inspector General himself, Lordship, the annexed the order, which is in page 43, Lordship. The similar order, Lordship, at page 43, this Honorable Court allowed the proportionate pension, which was annexed by the officer, Lordship. The Deputy Inspector General wrote the letter and annexed the order passed by this Honorable High Court, Lordship. But later on, Lordship,
1 minute.
it was denied the petitioner for proportionate pension. Hence, this writ petition before your Lordship, and some common judgment were allowed, passed by this Honorable Court, Lordship. Lordship will find at page 46. The writ petitions were allowed by this Honorable Court for proportionate pension, and the eligibility of proportionate pension, Lordship, more than 10 years up to or less than 20 years of service rendered by person under the government of Assam, they are eligible for proportionate pension, Lordship. And Lordship will find at page 58, Lordship. And I may be read at page 59, Lordship. At page 59, Lordship. Page 59, counsels for the petitioners have also relied upon the judgment of the Apex Court in DS Nakara and others versus Union of India, reported in 1983, 1 SCC 305, to bring home the point that there cannot be discrimination among personnel of the border organization of Assam Police and the other departments of the state government in violation of Article 14 of the Constitution. The petitioner's case is also that there cannot be a cut-off date of 20 years for being eligible for getting pension, as the cut-off date of 10 years as reflected in Rule 108B can also be applied to these present petitioners. Counsels for the petitioners also submitted that Rule 108B of the Assam Services Pension Rules 1969 does not exclude the petitioners in any manner, and as such, non-application of the said rule in their case and denial of their pensionary rights is violative of Article 14 of the Constitution of India. Counsels for the petitioners have also relied upon the judgment of the Division Bench of the Court dated 28/2014, rendered in read appeal number 289 of 2014, Sri so-and-so versus Director General of Assam Border and others, wherein the Division Bench had considered the case of a head constable in the border organization of Assam Police under the PIF scheme 1987, who had rendered less than 10 years of qualifying service. The Division Bench of the Court, by the aforesaid judgment, upheld the decision of the single bench and dismissed the writ appeal on the ground that the appellant therein did not complete 10 years of qualifying service for being entitled to get compensation. Para 11, 12, and 13 of the judgment and order dated 28/2014 passed in writ appeal 289 of 2014 read as under. that para 11, the order dated 23/9/2011, amongst others, provides that ex-servicemen would also be entitled to pension against their services in civil employment, subject to completion of qualifying service. It is not in dispute that full bench is payable after 25 years of qualifying service and proportionate pension is payable after completion of 10 years of qualifying service, Lordship. Lordship, it is clear that the person who renders service more than 10 years, up to 20 years, those are eligible for proportionate pension. Hence, this writ petition, Lordship, and other candidates who applied, who approached this honorable court, Lordship, their petitions were allowed for proportionate pension. And here also the Superintendent of Police, he communicated to the Deputy Inspector General, Lordship. They firstly admitted, even annexed the writ petition, so-and-so, Lordship, which was considered by this honorable court, and the person is getting proportionate pension. But later on, Lordship, the petitioner was denied. Hence, this writ petition before your Lordship.
Let us hear facts.
Lordship. Lordship. Lordship, what happened? He rendered 70 years, 2 months, and 26 days. And he is eligible for proportionate pension. And the application submitted by the petitioner, which is in page 41, Lordship, and in page 42, the Superintendent of Police Border communicated to Deputy Inspector General of Police, Lordship, page 42, annexing the writ petition, the order of the writ petition 1158 of 2015, which was allowed. He was the person who rendered service under this organization, Lordship, border organization. But in case of the petitioner, Lordship, later on the Deputy Inspector General of Police denied, which is reflected in page 45. In page 45, Lordship, Annexure 8. From the Deputy Inspector General of Police, Lordship, to the Superintendent of Police Border, Lordship, regarding the proportionate pension of the petitioner, Lordship. The last paragraph, Lordship. Therefore, Sri Jogen Chandra Hazarika is not eligible for proportionate pension and other benefits except GIS and GPF as per the Rule 24 of Assam Services Pension Rule, Lordship. And before that, Lordship, above that paragraph, the head constable so-and-so had already resigned his service under PF scheme of border organization, so-and-so, the effective from so-and-so, Lordship. And this letter, Lordship, denied the petitioner from—
What is this? PF scheme of border organization?
PF is PIF, it should have been
PIF.
also. Prevention of infiltration.
PIF scheme of border, you have a type copy? Oh. What is it? This is not legible.
That is,
Border organization?
Lordship, PIF,
No, after that. After that.
border organization.
What is this?
It was the prior to the effective date, Lordship. It is prior to the effective date with effect from
Where's
one,
the PIF scheme?
Lordship.
Where's the PIF scheme?
There is something 3940, but it's not, it does not refer to be the full scheme. Some conditions are there, page 39 and 40 also.
Annexure 5, Lordship. Under this scheme, some ex-servicemen were recruited, Lordship.
No, this is not a PIF scheme, isn't it?
No, it
Is
is
it
not.
the PIF scheme?
It is not
The
the PIF
conditions.
Where's the
Lordship.
PIF scheme? When is it effective from? When is the
Lordship.
PIF scheme effective from? The effective date of PIF scheme. Because you resigned on 27/4/2010.
Lordship.
What is the effective date of the PIF scheme?
Prior to that, in the impugn order itself, your lordship must have seen. Prior to that, there is one statement, page number 45, your lordship.
I'm on that.
Lordship.
You have a copy of the PIF scheme?
No, your lordship, not with me right now.
Get a copy. After
Lordship.
that, we'll know whether you are entitled to the PIF scheme. Proportionate pension.
Lordship, the page number Lordship will find the page 43 Lordship. In case of Govinda Boisya also Lordship.
Hmm.
The same, he was also served in 2015 Lordship. This petitioner also approached Lordship.
No, that's fine, but then
Lordship.
when did, there's no mention that on which day he resigned. Is it a covered case?
Lordship.
No. In my humble submission, it's not, because all the other cases which is referring to, there the persons has retired or promoted and retired or something like that, your lordship. This time here, the person has resigned, your lordship. So it will not be a covered case in the strict sense of the term, your lordship. I don't believe it will be a
So
covered
that's why I'm saying, where's the PIF scheme?
case, lordship.
You produce a copy of the PIF scheme.
PIF scheme. Lordship.
But Mr.
SK Sarkar.
SK Circle and also. Can you produce? Can you produce? I think you should have the scheme.
Much.
You are for this.
Government, your lordship.
Mr.
C.S. Hazarika, your lordship.
C.S. Hazarika, Leonard Standing Council.
Junior government advocate, your
Leonard
lordship.
Junior Government. It shall produce a copy of the PIF scheme. Stop date. List the matter again on after
2 weeks, your lordship.
after 2 weeks.
Lordship. Observe, your Lordship.
24-25.
Lordship, in this matter, before my learned senior starts, Lordship, I would like to advise this court, Lordship, although social justice has been implemented as a party respondent, but copy has not been served to us, Lordship. Today only, right now only my friend has informed me. May I pray for a copy of the petition, as well as 6 and 8,
Social justice.
Lordship. They have been implemented as respondent number 6
To everyone.
and respondent number 8 is a commissioner for persons with disabilities.
Social justice. Respondent.
Government advocate. You understand me?
So, तेव्हा appear करशील दोन दिना तेव्हा notice लयसे आम्ही ते accept करूस तेव्हा आम्ही गोष्ट In any case, I can hand over a copy to you right now.
I'll provide.
So I have an extra copy.
Today only I have received a copy. Sometime I can be granted.
Lordships, in any case, the matter does not relate to my learned friend. The matter relates more to the PHE department, Your Lordships. What has happened in the matter is that the husband of the petitioner had met with an accident while in service. And thereafter, pursuant to the accident, he was in the hospital for several months, Your Lordships. He has attained 100% disability because of the said accident. And the Right to Persons of Disabilities Act mandates that if an employee of a government acquires disability while in service, then his services cannot be dispensed with. He has to be, even if he is unable to render his services, he has to be accommodated in a supernumerary post and will be entitled to all salaries which are due to him as if he was continuing to serve. Now, from 2019, that accident occurred in sometime in the month of June 2019, till date, Your Lordships, they have paid me approximately 10 lakh rupees as an interim arrangement. But the fact remains that my husband is in extremely dire circumstances and I'm financially absolutely broke. So this is the second round of litigation before Your Lordships. In an earlier round of litigation, an order already was passed by this honorable court to verify whether my husband had acquired a disability, whether that disability is 100%, And if so, they were directed to act in terms of the mandate of the Rights of Persons with Disabilities Act. They did not do that, Your Lordships. They did the medical assessment. They came up with the report saying that I am 100% disabled, but an advice was given by the respondent number 12, that is the Administrative Reforms and Training, Pension and Public Grievance Department, saying that they should act in terms of Rule 82 of the Assam Pension Rules. Now, Your Lordship, that rule cannot be applicable now, considering the fact that a new law has been brought in. So the normal, the general areas, special habits, non-detergent, the maxim which applies right now is that when a special law is brought in, then things general cannot be applied. So thereafter, we challenged that particular notification whereby Rule 82 was tried to be brought into the case of this, and this is where we are in this petition, Your Lordships. I had also filed a contempt case against them, which is also pending, which is the second case before Your Lordships. Now, in this matter also, on the last occasion, my learned friend made a submission saying that if I am able to produce a certificate of guardianship, because my husband does not have cognitive abilities. He cannot recognize or he cannot talk, or he's 100% disabled, Your Lordships. So, and a submission was made that if I am able to produce the local guardian certificate, then the salaries and the dues, whatever is due to him, will be released. Immediately, Your Lordships, we had already applied for the guardianship certificate, and during the course of the proceeding, I produced that certificate before Your Lordships. It is also must be a part of the record. In any case, in terms of the last order, I went and approached the authorities, and I have submitted all the relevant documents. Till date, Your Lordships, the last order was passed sometime on yes, the last order. Your Lordships will find the last order was 20th of September 2023, Your Lordships. And yet they have not paid me a single penny, Your Lordships. The fact remains that it is extremely difficult on my part to even treat my husband, Your Lordships. For the basic requirements also, it's becoming a problem. I have 2 minor children whom I have had to withdraw from the schools that they were studying in, and I've had to place them in institutions where, in a Don Bosco Institute, where the fees is a little less, Your Lordships, because it is a Christian institution. Their fee structure is a little less. And unfortunately, they don't seem to be doing anything much. Now, on the last occasion, if Your Lordships will find, I'm taking Your Lordships to the order dated 29/2023, passed by this Honorable Court. In paragraph 6 of that order, of this court's order, Your Lordships, I'm reading, Mr. R. Gogoi, learned so-and-so, submits that he has received instructions from the Deputy Secretary to the Government of Assam to the effect that if the petitioner can produce a guardianship certificate with respect to her husband from the office of the Deputy Commissioner, Kamrup Metropolitan District, the pay and allowances payable to the petitioner's husband as Assistant Executive Engineer would be paid to the petitioner. This remains unfulfilled, Your Lordships. Despite the fact that I have placed the certificate, I placed the certificate on the same day, Your Lordships, during the course of the hearing of this particular matter. It is already there. And I had also, in pursuant to this order, I also approached the authorities and I have handed over the entire documents formally, yet they have not made any payment, Your Lordships. And there was a further direction to this to the authorities to create that supernumerary post, which is as required under the law, Your Lordships. That is where we are as of date, Your Lordships. I do not know what my learned friend would have to say today.
I like to hand over communication. No, we are not disputing. We are totally agreeable to what has been proposed, madam. So as regards the supernumerary post, that is under process. So report of the medical board has been received, and as regards, my lord, the personal department of personnel has been moved. And the other aspect regarding, my lords, that payment and allowances, that has also been sent to the AG to prepare a report. Because, my lord, this person, unfortunately, my lord, he could not attend his duty. So there are some criterions to be fulfilled. So that is under process, my lords. We are not disputing, my lords. We are agreeing to that, and we are creating. We have moved the personal department that please create a supernumerary post for this unfortunate person. And as regards the other aspect, my lord, this
AG has been moved to prepare a report, how much is admissible and how much it will take time.
Lordships, I had moved the first writ petition on 11th of November 2022, exactly 1 year back.
You are Gogoi,
I'm D. Gogoi, he was my colleague.
D Gogoi.
Yes.
You're taking a very long time.
My lord, at the first instance, my lord, we had sought suggestions from this department of my lord.
One statement is clearly recorded by this court, saying that if the petitioner produces the guardianship certificate, the amount will be paid. That was on 29/2023. On that day itself, petitioner has produced, isn't that you
Yes, sir.
produced that copy?
Yes, yes, in the court itself.
I don't have the copy.
It,
here,
it,
but
it should have
the-
been, in any case, I have also produced it to the deputy secretary as directed by the order, your lordships. I have a copy diya
When
hamari,
did you
yeah,
produce it?
disability certificate. Dila?
When did you produce it?
Lordships, immediately after the next day itself, she has gone and appeared before the authorities along with a copy of the order, maybe perhaps 1 day after, your lordships, after getting a copy of the order, she has gone and produced the certificate. And this was handed over to my learned friend also. In court, I had handed over a copy of this to my learned friend and to this honorable court also.
That is a different aspect. This is taking time. Like my lords will take it up at 2. I'll have some instruction what time it is going to require. Other my lords, since though we have sympathy with the person, but some things takes time, my lords, because a report has to be prepared. He was under leave. How much is admissible? How much is to be paid? My lord, this calculation requires my lord some time, my lords. I'm not disputing. I'm not denying anything. We are agreeable. We are also
From
in support of this
2022,
law.
you're not doing anything.
No, no, it has been sent. It has been sent. So some proposal
At the
has
letter stage, at
My
the
lord?
much later stage, which is not appreciated by this court.
We understand, my lord. I apologize for that. Lordship will take it up. I'll have a word with the secretary.
Okay.
Proper time at what time? But my lordship will appreciate that we are doing our best. Some things take time, my lord.
Lordships, the point remains that when I had filed this second writ petition, an amount of approximately 36 lakhs was due to the petitioner.
Out of which
And
10
out
was
of which 10 has been paid.
So-
So approximately 25 lakhs still remains to be paid. And he's agreeing to that. Assuming that they have to make calculations, it could not exceed 25 lakhs. It would perhaps come to about 5 lakhs, 7 lakhs, which will be deducted from the leave which I was entitled to. Once the supernumerary post is created, thereafter they have to pay me the regular salary. That is clear. So even assuming that 7 lakhs or 10 lakhs also is to be deducted from this thing, at least the balance 15 can be paid to me. There's a loan which my husband had undertaken, which I'm not being able to repay, your lordships. Now the bank is asking for mortgage of my house now. They're not, while they are doing all these things, the fact remains that if they at least release part of the payment which is due to me, that would be a big relief for the petitioner, your lordship. That is my only concern. So when he takes instructions, perhaps if he could take instructions on that as well, that a part payment could perhaps be made.
Yes,
That
but
much.
you can also take back. So whichever some part payment can be made to the
Yes,
petitioner. You take instruction.
Yes, at 2, my lord.
Deeply obliged.
$26.
May I please your lordship? My lord, I take your lordship this judgment.
Lordship, I am appearing on behalf of respondent number 6 here. Over telephone, she has informed me that the service, she has received the service notice, Lordship. So I'll file wakalatnama, Lordship, within 3 weeks. 3 weeks time may be granted.
You're entering appearance.
Lordship. Over telephone yesterday.
Yes.
Small matter.
Take a lordship.
Mr.
A.R. Tohapilda.
A.R. Davildar, Legal Counsel, enters appearance on behalf of respondent number 6. And waits for 3 weeks time. Not to file counter.
No, Lordship, wakalatnama, it's power.
Why you want 3 weeks time to file power?
Then I'll go to and Lordship, I'll file response also.
Okay, to file wakalatnama as well as counter affidavit. So. List after 2 weeks.
Obliged.
Give up.
$27. Hearing part of nothing.
May it pleases your lordship, lordship can be taken after some time, lordship.
This was the matter concerning, only that part, whether the subsequent appointment is a re-employment, so as to debar the pension. The matter was heard at length. The only crux of the matter is that they were to show a document to substantiate the claim of subsequent appointment. That much. My lord was pleased to hear the matter at length. It was interpretation of Rule 7, sub Rule 2 of the CCS pension rules, my lord. That's what.
Okay, let
After
us,
some time.
After some time, they will.
What?
28.
Similar prayer for this also.
okay.
Much.
Whatever.
Awesome.
29.
It please your lordship. Lordship, there is another writ petition, my lord, arising out of the same penalty, which is an effect in this particular writ petition. That writ petition may also came up today. So that may also be tagged along with this writ petition. my lord.
It came up today where?
Today in court number 13, and we made the mention before that court, and the court said to make the mention before lordship.
So both of you are agreeable? On request made by the parties. On request made by learned counsel for the parties. List this matter along with WBC number
3275 of 2015.
3275 of 2015.
15. And
After?
December.
After 4 weeks, my lord, because in this case, yesterday they have filed an affidavit. We have to.
Deeply obliged. It's going
30.
deeply obliged. It's going if a date could be fixed, my
12th.
great. My lord, deeply obliged.
I feel as if the other party is not present on last occasion also 2-3 occasions. And let's say I have taken instructions. The petitioner is no more. Lord. He expired. The other side is not appearing for last 2-3 occasions, Lordship. And in fact, I tried to make them contact also. They said that they do not know about the case. The old pending case, Lordship, the new. Lordship, may kindly peruse the death certificate. Lord. Petitioner.
No, it's not a question of they not appearing. It was you taking time.
Lordship, yes, they are not appearing. Court says that even they don't appear, Lordship. Lordship, court asked me to submit some instructions, Lordship. But now, Lordship, it is come that he is no more, Lord.
Let us give them one chance.
Lost,
No. None appears for the party. Mr. Enupadia, whether standing council irrigation appears for the irrigation department. This is the matter again after 2 weeks.
Lordship, they will be part of the record, Lordship.
Yes. Mr. Obadia appearing for the irrigation department, cancel the first line. Has furnished a death certificate of the petitioner, which indicates that he died on 6/4/2021. Stop. The same is this on the
Obliged.
list of the 2 weeks. If they come, you inform. Yes, please.
Well, look, I had a discussion with the deputy secretary. Verbally, my lord, he has advised me that we are awaiting the report from the AG as to what is the admissible amount the person is entitled to. As what has happened, my lord, this person has already exhausted his quota of whatever a person is entitled of that leave or leave period. So we're just awaiting that report. And AG has also raised a query. Verbally, my lord, they will probably issue a letter tomorrow. Their additional queries are there, my lord.
What queries?
That we are not in
And how about the part payment?
part payment, any payment minor will be subject to the report of the AG, madam.
Well, how early can you get it?
We are expeditiously pursuing it, madam. We have even we issued a reminder, madam. So let the AG also come and just help us out, madam.
AG is a party here.
Yes, AG is a
Accountant
party.
General is a party, yes, Your Lordship.
Who's the AG?
Accountant General party,
Yeah.
right?
Respondent 5.
Respondent number 5.
I'll give you 1 week's time. I'll give you 1 week time. By that time, you'll have to finalize everything.
Okay, that's-
3rd MS RS Chowdhury, let me talk for it. Mr.
D Gogo, for the PhD.
D Gogo, is it?
Yes, ma'am.
Then the Standing Council PHE has produced a communication dated 6/10/2023, created by the Deputy Secretary to the Government of Assam, PhD Department, PhD, and addressed to the Principal Accountant General, Assam, requesting to furnish leave admissibility report in respect of the petitioner, including half-pay leave for grant of leave, etc. Stop. He has also produced another communication dated 2nd November 2023, written by the Deputy Secretary to the Government of Assam, PhD, where it stated that the matter relating to creation of supernumerary post in the rank of AEE within bracket PhD in respect of the petitioner has already been sent to the personnel within bracket B department for approval for creation of the said numerary post after taking the approval of the senior most secretary, PhD department. Stop. Para. On consideration of the communication dated 6/10/2023, the Office of the Accountant General is directed to take immediate steps for furnishing the leave admissibility report to the concerned department. Stop. For taking such steps, 1 week time is allowed to the Office of the Accountant General. Stop. On the next date fix, the Standing Council Accountant General shall apprise this court with regard to the steps taken in terms of the order passed by this court. Stop. List again on today's 7th.
15, 16 Your Lordship, as per
16th.
16.
SC Social Justice and Empowerment Department may also be reflected in the call letter.
Registry is also directed to reflect the name of the Standing Council. What Social Justice and
Empowerment Department.
Empowerment Department in process.
All right.
Deeply obliged, Your Lordship.
27, hearing.
Vanik, I think we'll defer this to another date, maybe next coming Thursday,
That would be,
9th.
Ninth.
Today-
Could
today-
it be later than ninth? I would not be in station on ninth, my lord.
Or any day.
Ninth.
Next week,
Ninth.
Give you a convenient date on a hearing date.
16th,
14th, my lord.
14th or
14th.
16th.
14th.
This matter again on 14th. I have some problem with it.
It's a Pathan, my lord.
Yes, but
Pathan part.
finish. Oh.
Also be tagged with the, because relief sought by both of us are the same. So my prayer is that these
What
are
is there in your IA?
in my IA to expunge, same thing.
There are two IAs it seems. One is for expunging and one is for impleading.
Impleading in that case.
By mistake, not me.
No, mistake নহয়. আহক তেতিয়া I will, because I did not get your copy.
Yeah, but
So-
then there were some allegations, no? Which are
File two IAs.
Two IAs.
What for? One for?
One for impleading me in the I filed by Ms. Saikia, and another for my own expunging of the observations in against me. So these two IAs are filed. Because the subject matter is same, Lordship. So my prayer is that, or that all the three matters may be taken up together.
Okay, it is submitted by Ms. R. Majumdar. No, amicus curie,
Yes, Lord.
that she has filed two IAs. Being IA number.
This filing number they have given, Lordship, 1126.
Yes, it has
Okay,
not been
that's-
registered
okay,
as
that
it.
she has filed two IAs. Today?
No, they were filed, I think, 18/10/23 and 6/11/20.
On it.
Her, if you'll interrupt, Miss Saikia's IA can be taken up today.
Lordship, mine is
but,
separate actually. I have nothing like to be tagged with her RA. Her allegations, she can like deal with her.
No, what we are proposing is.
be impleaded, no?
Impleadment,
of course.
No, but she wants to be impleaded, Lordship. But
Let us, why not we take up the whole thing together?
Yes.
And then.
That
we
is why I
finish.
submitted. Otherwise, I do not mind if Lordship hears me my petition separately. I do not have. But then since same cause of action, it can be dealt with on the same day.
Yeah.
And she can start, no problem. I can do later on.
No, we'll call those two IAs, close the whole matter
Yes.
at one go. That will be better.
Okay.
Instead of lingering.
That
Yes.
is of course.
It's just
So,
only
no, that is
the
amicus
time,
curie that she has
everybody
filed
can
two
do it.
IAs on.
Lordship, when Friday?
No, when did you
Filed.
file it?
Oh, filed on one filed in 18/10/23, another
Friday
6/11/23.
Friday mo nathakim Thursday.
Connected with the
Thursday
president.
মোৰ PIL আছে, petitioner in person, court number 1. তাৰ পিছত এড টু যদি
Registry
দি
to
দিয়ে,
verify and place the same
কৰিব পাৰিম।
সেইটো কৈ দিম।
on record.
When?
And this matters on when?
Any day.
Lordship, can it be on Thursday?
1 minute.
Thursday, I have a PIL Lordship petitioner
Which
in
you
person in court
convenient
number 1.
Sister, when is your convenient date? Okay. Monday,
Monday is the
holiday.
holiday. Monday is next Tuesday.
Tuesday.
Tuesday,
November niki?
14. Okay.
14th.
Is it okay?
Lordship,
14 November.
On Tuesday.
deeply obliged, Lordship.
Of